Well, hi there, and welcome to the Employment Law Show. It's good to have you with us again this week. My name's John Scholes. Beside me, of course, employment lawyer Lior Samfiru, always reachable after this half hour, in between the half hours, whenever you like. Just reach out to Lior. Phone call is always good, right? 1-855-821-5900. help@employmentlawyer.ca is the email address you can always go to. And the website, that is handy. It was built just to make you smarter, so easy to navigate. You learn so much even before listening to our radio shows or even watching this TV show. Even before a phone call to Lior, it's pocketemploymentlawyer.ca. Rolled into that is a severance calculator. Details on that in just a little bit. And our main topic, all about bonus payments for employees, a little later on the show. So we got a lot of ground to cover, and phone calls from our live radio shows across the country. So that said, Lior, let's tuck in and do it, pal. It always starts off with the week that was. What do you got cooking?
Hey, John, great to be here, Employment Law, to talk about this topic, to make sure that our good viewers know what their rights are. You know, by watching the show, you'll be in the kind of top 5% of people in terms of knowledge of employment law. There's a lot of misconceptions there. Every single day, you know, when someone finds I'm an employment lawyer, let's say I'm out somewhere and they come ask me a question and I realize that they're laboring under misconceptions. They believe things that are not true. They've thought something or believed something their whole life, and it's wrong. So that's why I'm glad to have this voice, this opportunity here to tell you what you actually need to know, to tell you about your rights, to tell you about what to do if you're facing a workplace problems. I hope that for the most part your job is going well, your boss is treating you properly, and you don't really need me. But if every once in a while something comes up, maybe your boss did something, your job is changing, maybe the business is sold or not doing well, and you want to know what this all means to you, you have to know and understand your legal rights. And I said legal rights because you have them. They're there for you. Whether you know it or not, they're there. Now you're going to know it. Now we're going to tell you what to do. You lost your job. You're being mistreated, discriminated, bullied, job changes, pay reductions. You name it, we cover it. And of course, beyond just these 30 minutes, not going anywhere. My team and I, you can reach us always. We'll give you that contact information throughout the show so that we can roll up our sleeves and help you. On this show, you know, I can just tell you things. In real life, I can actually roll up my sleeves and get to work. So don't ever hesitate to call us. And let me start off with the situation that came across my desk. This particular lady that called me suffered from what I often refer to as the double whammy of employment law. What happened to her is she was off on a disability for about 1.5 years, or going on 2 years. And she gets a letter from her insurance company saying, we think you can go back to work. Why they thought that, I don't know, because she couldn't. So we're going to be cutting you off soon from your disability benefits. Well, wouldn't you know, not 48 hours later, she gets another letter, this time from her employer, telling her, we hear you're ready to come back to work, so we'll be expecting you back. And by the way, if you're not coming back, we're going to consider you to have abandoned your job. So distraught, she's still sick, by the way. She's still unable to work. She's still in physiotherapy and struggling significantly. She calls me and said, what do I do with this terrible situation? I'm going to be cut off benefits and I'm going to be considered to have abandoned my job. Holy cow, what do I do? So let's be very clear. Let's break this into the two pieces. Her insurance company should not be cutting her off because they decided arbitrarily she can go back to work. If her doctor knows and she knows that she can't go back to work, the insurance company should allow her to stay off. They shouldn't decide arbitrarily, unilaterally, that she has to go back. Of course, they want her off their payroll, but they still can't do that. So we're going to get involved. We have a whole team at the office dealing exclusively with these insurance issues, disability insurance, making sure that she's either not cut off benefits or gets compensation from the insurance company. Now, with respect to her employment issue, no, it doesn't matter what the insurance company says. She can still continue to be off work so long as she has a doctor's note saying that she needs to be off. Her company cannot ignore her doctor's note. They cannot go beyond that doctor's note. So if they consider her to have resigned, that's a wrongful dismissal. That could be a human rights violation. I assure you, once I get involved, it's going to be fine. But if your insurance company is cutting you off or your employer is putting pressure on you to come back to work before you're ready, remember, that's not right. That's illegal. And you absolutely must give me a call.
Well, we know from our other show, Lior Disability Law Show with Savannah that hosts that, and James and Tamar right here as well on the opposite weeks, that, you know, sometimes it's around that 2-year mark is when that insurance company comes knocking and says, yeah, we've had enough of paying you. It's time to go back to work. As far as the employer is concerned, though, how much They say, okay, you're not ready to come back to work. That's what you're saying. We want to know why. You know, has that healed yet? Have you fixed that yet? How much can they know and how much can they ask for as far as how ill you are and being off on disability?
Listen, an employee is entitled to privacy, and your personal private medical condition is private. Your employer doesn't have a right to know if you're suffering from this condition or that condition, what medication you're taking. They don't have a right. Now, the insurance company does have a right to know that information. You have to produce information to your insurance company, but not your employer. The only thing your employer should be asking to know is whether you can work, for how long you may be off, and whether you can be accommodated. That's it. Whether you're suffering from mental health or a physical ailment does not matter. You don't have to give that information, and you can't be punished for not providing it.
You know, I'm thinking a lot of people watching who are maybe both or they're off work because of a disability, they are thinking, okay, what happens, A, if my employer switches insurance companies, or if the plant shuts down and they go bankrupt and I'm still on disability, do I lose my coverage? Because there's that connection I've always had by paying into my benefits at work. I no longer have that workplace.
Yeah, so your status as an employee is not going to affect your disability coverage. You should be staying on disability coverage until 65 or until you're no longer disabled, whichever happens first. So if you quit your job, if you're let go, if the business shuts down, does not impact your disability rights. Those rights crystallize when you become disabled, when you're unable to work. So don't stress out over it. But of course, you have another safety net. If anything happens and you're questioning the validity of it, just give me a call.
And that number, by the way, as we get into our first phone call, 1-855-821-5900. Anytime to reach out to Lior and his team. Okay, employmentlawyer.ca. I did mention radio shows pretty much across the country. We've been doing that since we were young guys. Had a lot. Younger guys. You can reach out to employmentlawyer.ca, find a station near you in a market that carries our radio show. You also have the opportunity, whether it's a 30-minute show or a 1-hour show, to call in and ask questions. That's the beauty of it. We play them back here. We talk about it. We do 3 per show. Phone call number 1 is coming up right now. Listen up.
I worked for a company probably almost 22 years, and then I was laid off. But in the meantime, the company was sold, but I was laid off. So then I got up to a pretty good wage, and now the boss calls me in and he wants to sign something. He's just going to let me go, and he wants to give me 2 months' salary.
What's the position you work in?
Mechanical engineer.
How old are you right now?
56.
Happens often, by the way. You work for a company, you leave, and then you're kind of brought back, and then you let go again. Well, the question ultimately becomes, what happens to your seniority? So in this case, he had 22 years previously, and he was brought back and worked maybe for a short period of time, then let go. So does he get credit for the previous years? In most cases, the answer is yes, he does. He may be getting credit for full years, even though there was a break in employment there. In most cases, depending on the length of the break and also depending on the terms of employment that you were brought back in, did they treat you like a brand new employee, or was there an acknowledgement that you worked there before? Well, in most cases, there's going to be that acknowledgement, meaning you do get credit for the time you were off, or so not the time you were off, the time you had previously. So the more time you have credit for, the more severance you get. So this person is not a new employee. He has his 22 years of service with him despite that gap in employment, and he must be paid severance on that basis. Same to you at home if that happens to you. So the last question, of course, that we need to answer is, how much severance does he get given his 22 plus years of service? Easy to find out. You can do that as well. It's free and anonymous. Just go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. Click on the severance calculator. Use that tool to find out for yourself. We're going to do that right now in this situation to see how much severance he's owed. So on the severance calculator, we see that he's a 56-year employee, he's a mechanical engineer, has 22 plus years of service. Company says, yeah, we're going to give you 2 months severance. Not so fast. You see there, he's owed right around 24 months paid. 24 months. That's a big, big difference. That's 12 times more what he's been offered. That's why it's so important to use the severance calculator or to call me and make sure that you know what you're owed.
It's interesting, though. You mentioned, being recalled. It's how they treat you as a new employee or, just coming back to work. Is there any telltale signs like, oh, yeah, Sam, your coffee maker and your stapler are still on your desk, therefore, you're just kind of coming back to work, right?
Well, there's a number of things. If there's an employee number, do you have the same employee number? When you're hired back, did they make you sign a probationary clause? If they do, it's going to be tough to say you're an old employee. On the other hand, if they brought you back without probation, you just kind of continue where you left off, more likely that severance or seniority carries through. So there's a number of things to look at. Ultimately, are you treated like a brand new employee that just walked off the street, or are you treated as someone that was there before? If you're treated like someone that was there before, you'll likely have that seniority carry through, which means if ever you are let go, you get more severance.
All right, there's phone call number one. Phone call number two is coming up right now. Lisa?
I'm an over-the-road truck driver. Our company was purchased by a major company 2 years ago next month. Last week I signed my yearly review. It said date of employment, where in actual fact I worked 3 years for the company that they purchased. Should that be written on that form, or does it matter?
Question. Great question.
Yeah, so generally speaking, if a company is bought over and continue working, they inherit your service. So generally speaking, on a performance review document, I don't really care so much if it doesn't specifically say that you had the previous years. Now, if you signed a brand new employment agreement when you took the job, and it says, just so you know, employee, we will not recognize any prior service, that's a problem. But if you never signed anything like that, and now that performance review says you're an employee of 2 years, or you've been there for 6, it doesn't matter. I wouldn't stress out over it. Where it becomes extremely important is if you are let go, remember that the time you had with the previous company must count towards your severance. The more time you have, or the more seniority you have, the more severance you're owed. So in a sale of a business, generally, it's not just the time you had with the last company that counts. It's all the time you had with the previous company or companies that all counts towards your severance.
All right, Lior, good stuff. The phone calls always come in threes, but the third one's coming on the other side of the break, and then we'll get into our main topic, all about bonus payments for employees. That is on the way as we continue with more of the Employment Law Show. Stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Employment Law Show. I'm John Scholes. With me, of course, again this week, Lior Samfiru. Always reach out to Lior at the firm, stlawyers.ca, or help at employmentlawyer.ca. And the phone number works well, 1-855-821-5900. As I always mention, go to employmentlawyer.ca, the media page, and find a radio station in your market or close by where you can tune in, and online, of course. Catch the radio show weekly, Monday to Friday, and weekends as well. It's 30 minutes, 60 minutes. We're all over the place. But the key point is you can call into most of the shows and ask your questions. We play those calls back here because they're educational, and we like to talk about them. We always do 3. Lior, phone call number 3 is coming up right now.
If there's a contract, an employment contract that needs to be signed, I guess the contract says it as a fixed-term contract. The employee's been there for many, many years, in this case, 17 years. They're suggesting that that's a fixed-term contract. They have to sign it. What is the downfall if you don't sign that contract? But you're still employed and you're still working now without an official live contract.
A lot with teachers, right?
It happens often. Teachers, private school teachers, they may sign one every year, or many other jobs as well. So let's start with the end of this question, which is what happens if I don't sign it? They told me sign it every year, and this year I say no. Well, what could happen is that the company may let you go because of that. Why? Well, because a company is allowed to let you go pretty much for any reason as long as severance is paid. Now, they would have to pay you severance, but ultimately you may lose your job. So you may decide, I'll kind of play along and sign this agreement because I don't want to lose my job. But here's the thing to remember, though. using this example, 17 years, probably signs a contract every year. That contract is meaningless now. It doesn't do anything. He's now an indefinite employee, which means if he's let go, he's going to be owed full severance if the company decides not to renew the contract. So after all these years, maybe you just sign it because you don't want to lose your job. But what I want you to remember, this is not just for this particular person. Anyone that keeps signing contracts year after year, if at some point the company says, that's it, now you're actually done, we're not going to renew the contract, we're not going to give you another contract to sign, you're owed severance. And if he's been there for 17 years, he could be owed 18, 22, even 24 months of pay. So yes, even with a fixed-term contract that keeps getting renewed and signed, you may be owed severance if this happens often. Keep that in mind. And of course, always, fixed-term contract, no contract, verbal contract. If you are let go, call me.
Beyond this, 17-year example, Lior, when does that contract, after 2, 3, 4, 5, they become worthless and pointless, I guess, for that matter?
We look at the totality of the situation. For me, generally speaking, I need to see at least 3 contracts before I can say, okay, you're not a fixed-term contract. That's not a hard and fast rule. In some cases, you need more, and sometimes you need even less than 3. But generally speaking, 3 contracts, if you're now gone beyond that, you've signed 1, you signed the second, the third, well, now the law's going to say enough is enough. You're now an indefinite employee, and that means, again, severance will be paid if you lose your job.
So quickly, using this example, 17 years total, you say maybe after 3 contracts. So does his severance, if he got let go, is it for 14 years because he had 3 contracts previous, or it goes back to day 1?
It goes back to day 1. So that means, of course, more severance. Of course, as always, the more years of service you have, the more time you have with your employer, the more your severance is going to be.
Main topic, let's get into this. All about bonus payments for employees. Number 1, revoking or eliminating a bonus payment can lead to constructive dismissal. Clark?
That's right. Nothing teaches us more about employment law than National Lampoon's Christmas Vacation. Exactly. So, but joking as we may be, that is actually true. If a bonus is a regular part of your compensation, what I mean by that is if you get it every year, you generally know how much it's going to be. It's something that you rely on and count on. If the company takes it away, that can absolutely be a constructive dismissal. Now, if it's a tiny bonus, it's a tiny fraction of your pay, it may not be enough to be a constructive dismissal. But if it's a substantial bonus, maybe it's 10, 15% or more of your pay, and the company says, this year we decided, forget about it, no bonuses for anyone, kind of like the Clark Griswold situation, that may be a constructive dismissal. You may not necessarily be able to force the company to pay it, but you may be able to treat that as a termination of employment and get severance. So always remember, if it's part of your compensation, it really shouldn't be taken away.
Number 2 about bonus payments, Lior, is this: you are still entitled to receive a bonus even if you've earned despite being fired or terminated. So you still get it.
So I'll give you an example. So let's say you earned the bonus, you met all the targets, and it's based on the calendar year. But the bonus is paid, let's say, in March of the following year, which happens often. And you were let go in January. Mm-hmm. So you've earned the bonus. You did everything you had to do in the previous year, but you're let go before the bonus is actually paid, a couple months before. You still should be getting that bonus. You earned it. It's something you did as part of your compensation, as part of your job to earn that bonus. And the company cannot and should not choose a convenient termination date to deprive you of money that you've earned. Now, of course, we'd also want to see your employment agreement. That may change the analysis. But generally speaking, if you've earned the bonus, it has to be paid.
How often does that happen with employers? I mean, they may do it just through ignorance, not out of spite, but they figured, oh, we let you go in January. Why would I pay you something that comes up in March?
Absolutely. Happens all the time. All the time. I see this literally weekly where employers let someone go before the bonus is due. And yeah, you're right. In many cases, they're not doing it on purpose. They're not doing it to try to hurt the employee. They just think, well, because we're not paying bonuses in till March and you're let go now, we're not going to pay you. Wrong. It's simple. If you've earned it, you should be paid it.
Bonus payments for employees. That is the topic this week, as you know. Number 3, severance packages should include all elements of compensation, including that bonus payment.
Very important. This is really an issue that comes up all the time, very often, John. So let me break this down a bit here. If you were let go, first thing we'll do is to figure out the number of months that you're owed. Is it 6 months? Is it 12 months, 24 months, etc.? But the second equally important thing that we have to do is to determine what is included in that. So yes, base salary, it's obvious. No one's going to forget about that. But it doesn't end there. your severance has to include all components of your compensation, including bonus. So it includes salary, bonus, benefits, car allowance, if there is pension contributions, RSP contributions, you name it, all components of your compensation have to be paid. Now, bonus is very important. For many people, a bonus could be a very substantial part of their compensation. So how do we include bonus? Very easy. We look at what your average bonus payment is. So if on average you get a bonus of $20,000 a year, well, $20,000 a year, it's going to be calculated and prorated and included as part of your severance. So your employer may not include it, but now you know. If you're let go and your severance offer does not include your average bonus as part of it, potentially that's a wrongful dismissal, that's illegal, you know to call me.
We'll get to one more point here when it comes to bonuses for employees. Employment contracts can limit your right to bonus pay.
Yes. So I told you what the law does when it comes to bonuses and the protections that you have and what an employer can and cannot do. But all of that, or most of that, almost all of it, can be changed or taken away with an employment agreement. An employment agreement can give the company the right to take away your bonus, can give the company the right to let you go and not pay you the bonus earned. It can also give the company the right not to include it in your severance package. So you want to always be careful with that employment agreement. You don't want to sign something that gives the company such extensive and probably unfair rights. So the first thing I'll always ask you, if there's an issue with bonus, let me take a look at that employment agreement. For most people, in fact, the employment agreement does not deprive them of bonus, but it could. So if you're starting a new job or you're looking at a new employment agreement to sign, that's one of the things you want to watch out for. Can the bonus just be eliminated? You not get it even if you've earned it. So be very careful. And of course, if you're not sure what the agreement says, you know what to do. Send it over to me. Let me review it, and I'll tell you.
That wraps the topic for this week. Lots more to go. We'll get to a question from one of Lior's live streams he does during the week. I'll also give you contact information on how to join the live stream weekly as well. That's on the other side of the break. As we continue more of the Employment Law Show, we're coming right back.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Employment Law Show will continue on. I did mention before the break, Lior and his team do a lot of live streaming. It's a great way to contact the lawyers, have a chat, learn a lot more on Facebook, YouTube, LinkedIn. Just go to @STLawyers, @STLawyers to join in that conversation. Here's the question for this week, Lior. I was employed for 6 years in the sales department at my company. At 45, I was constantly bullied by a manager, and HR refused to investigate. I'm now on long-term disability leave with medical certificates from my family doctor and a treating psychiatrist stating I am unable to work. If I quit, I have no severance pay. What can I do? Should I just resign?
Well, that's another assumption. We've been talking about assumptions here. No. If you quit because of harassment, the law says that could be a termination, constructive dismissal, and yes, you get severance. The key, of course, is can you prove it? Can you prove what was done to you, how you were mistreated, bullied, etc.? If you have the ability to prove it, in other words, there's a witness, there's some documentations, emails, then no problem. Even if you quit in that situation, and who would want to go back to work in that situation? Of course, that is a termination. Full severance has to be paid. Remember that. Now, the last question in this scenario as well, okay, severance, but how much severance? We're going to go back once more to the severance calculator. You can find that at pocketemploymentlawyer.ca. Click on the severance calculator, use it free and anonymously, and let's see if we use it right now, what that gives us. So we know this person, 45 years of age in a sales role, been there for 6 years. Well, even if this person quits because of the harassment and can prove that harassment, severance is still owed, and we see 8 months of severance is probably the right amount, the amount that's going to be owed in that situation. So easy to use. Check it out for yourself.
Let's bounce over to terminationquestions.com, another free and anonymous website for you to ask questions anytime. Terminationquestions.com. For this week, the question right here. I'm 61 years old and have been employed with my company for 6 years. My job is very specific and unique to the company. I plan to give my resignation notice months in advance to allow ample time for hiring my replacement. I'm worried this might lead to an early termination. If this happens, am I still owed severance? Great question.
Yeah, and very good question. And it can sometimes get a bit tricky. The general rule is that if you give notice of termination and you're let go before the end of that notice, your employer still has to pay you until the end of that notice period. Now, of course, you can't game the system and say, I'm giving you 3 years notice, and if you let me go today, you have to pay me for 3 years. It doesn't work that way. Your employer generally would have to pay you your severance entitlements or until the date you were going to resign to begin with. So for most employees, your employer can't avoid paying you just by saying, you said the R word, resignation, we're going to let you go now and not have to pay you anything. It doesn't work that way. You still have to get paid. And of course, if that happens to you, I've said it before, say it once more, call me.
All right, thank you so much for those 2 previous questions. Now we move on to speeding things up a little with the employment rights rapid fire. Let's go. Okay, Lior, strap in. Here we go, pal. Rapid fire question. Number 1, are employees' severance entitlements based on the size of a company?
Very common misconception. No, your severance entitlements have nothing to do with the size of the company. Whether you work for a company with 1 employee, you're the 1 employee, or with 1,000 employees, you are owed severance. And by the way, that severance is going to be calculated in the same way, based on your age, position, and length of employment. You can get your full severance up to 24 months pay, even more than that, even with a tiny company.
Rapid fire question number 2. Can you be demoted as long as your wages do not change?
Generally speaking, a demotion could be a constructive dismissal, especially if it creates an embarrassing situation. People are looking at you, why were you demoted? Or it may hurt your future career prospects. So a demotion in many cases is a constructive dismissal, even if the pay stays the same. So remember that. You may be able to say, I'm not accepting this and I'm treating it as a termination. Now severance has to be paid.
We are into rapid fire question number 3, Lior. Are you obligated to provide private medical information to your employer when taking a leave?
So we touched on that early. The answer is absolutely not. Private medical information, therefore it's private. Your employer should not ask for it, and you don't have to give private medical information. Not what your diagnosis is, what medication you're taking, what kind of specialist you're taking. All of that is offside. You tell your employer if you can or cannot work. You can tell your employer if you need accommodation. If you know how long you're going to be off, you can tell your employer that. But beyond that, it's private and it's not appropriate.
This next one, we've heard this situation before, Lior. Rapid fire question number 4. Can your boss let you go so they can hire someone younger?
Generally, no.
Yeah.
If you're let go because of your age, well, we call that age discrimination. That's a human rights violation. So if the company wants someone younger than you and that's why they let you go, offside, not only is severance paid, we know that, but potentially because it's a human rights violation, there could be other very significant consequences. We don't have mandatory retirement, that's gone, so you can work as long as you want to, and your age should never form part of the consideration of letting you go.
Rapid fire question for this week. Number 5, can your employer refuse to provide a written employment contract?
Your employer can refuse, and you want them to refuse. You want to sit at home and say, please, employer, don't give me a written employment agreement. You would much be better off signing or not signing, starting a job on a handshake with an email, go to the back of the napkin and jot something down. That is all better than having a written employment agreement, which really only protects the employer. So yes, you don't want to ask for that employment agreement. You'd rather start the job without one. Be glad if that's your situation.
And one more rapid fire question for this week. Here we go. Are you able to ask for severance if you've resigned?
Well, if you've resigned because something was done to you, you're mistreated, or your job changed, absolutely, you can absolutely get your severance. If you've resigned because you want to work somewhere else or you've retired, then no.
There you go, and that is Rapid Fire for another week. We always encourage you to listen to all those, jot them down. Maybe it'll bring some questions you can ask or email for the next show. But to reach out any other time now that we're done to Lior and the crew, 1-855-821-5900, help@employmentlawyer.ca. And that website, we tell you about it every week. It's important, pocketemploymentlawyer.ca. We'll see you next time.